Overstayed your visa? June 2025 just changed everything. For years, if you overstayed your visa, you might have felt invisible, like you were off the radar. But starting June 2025, everything has shifted dramatically. The Trump administration has now officially declared visa overstays a top enforcement priority. That means IC raids, interviews turning into arrests, and green card or citizenship denials are happening at an accelerated pace. The June 2025 crackdown is real, and it's already begun. On June 1st, a new directive issued by DHS Secretary Kristi Noem was quietly circulated across all major immigration agencies: CBP, USCIS, and IC. The order? Immediate enforcement action against all visa overstays. Under her directive, immigration agencies are now actively reviewing records and initiating enforcement without delay. This once-hidden DHS memo has now gone into full effect, and the fallout is visible everywhere. ICE agents have been spotted making arrests at shopping malls, beauty salons, and even school graduations. There's surveillance outside USCIS interview sites. Visa overstays are being denied benefits, flagged for deportation, and having their citizenship applications reopened for fraud review. What makes this moment different is the shift in enforcement priorities. Before June 2025, visa overstays were often overlooked unless tied to crime or gang activity. Today, that same overstay from 2 years ago can now lead to detention or deportation. So what's triggering this? It starts with your I-94, the document that tells the government how long you're authorized to stay. Once your I-94 expires and you neither leave nor file an extension, you begin accruing unlawful presence. And the penalties are automatic. If you stay more than 180 days beyond your I-94, you trigger a 3-year reentry ban. Overstay more than a year? That's a 10-year ban. If you leave, re-enter illegally after that, you're permanently barred from the U.S. No green card, no waiver, no second chances. Real examples show the danger. Maria entered on a 6-month tourist visa, stayed 9 months with no extension. She triggered the 3-year bar upon leaving. John overstayed a business visa by 7 months, voluntarily departed, but still got hit with a 3-year ban. Lisa, who overstayed her student visa by 13 months, left to attend a green card interview, and unknowingly triggered a 10-year reentry ban. And under INA 212A9C, if you overstayed for over a year since April 1997, left, and later tried to reenter illegally, you're facing a permanent ban. No appeals. The only path back is to spend 10 years abroad, file an I-212 waiver, and hope for approval. Can overstayers still fix their situation? Yes, but time is critical. Waivers are available, including Form I-601 for applicants abroad and Form I-601A for those still in the U.S. These require you to prove extreme hardship to a U.S. citizen or green card, holding spouse or parent. Examples of qualifying hardship include medical emergencies, family separation, emotional trauma, and financial devastation. But waivers are not guaranteed. They're reviewed case by case and can take months or years to process. Some categories of individuals don't accrue unlawful presence even after visa expiration. These include children under 18, pending asylum applicants, VAWA petitioners, trafficking victims, and DACA recipients, assuming their status hasn't lapsed. There's a crucial loophole. If you overstay but never left the U.S. and married a U.S. citizen or have a U.S. citizen parent or spouse, you might still qualify for a green card without triggering the 3 or 10-year bar. For instance, Maria overstayed 9 months but married a U.S. citizen and adjusted status from inside the U.S. No bar triggered. The 2012 Arabali and Yarabelli case also created a new exception. If you have approved advance parole, you can leave the U.S. for your green card interview and re-enter without triggering bars. Ahmed overstayed his F-1 visa, married a U.S. citizen, got advance parole, and traveled for his interview. He re-entered legally with no penalty. A critical 2023 decision in matter of Duarte Gonzalez clarified that the 3 and 10-year bans continue to run even after re-entry, as long as you re-enter legally. So if your 10-year ban started in 2020 and you re-entered legally in 2024, it still ends in 2030, not 2034. But here's what's truly alarming. ICE has now been seen outside USCIS offices, including during N-400 citizenship interviews. People are being flagged, questioned, and even placed into deportation proceedings on the same day. USCIS is now rechecking how you got your green card, even if you've held it for years. If they find any signs of fraud or misrepresentation, they can void your green card and start removal proceedings. So what should you do now? Start with your I-94. Know your expiration date. Stop filing blindly and consult a qualified immigration attorney. Don't assume you're safe just because you've been quiet. Before leaving the U.S., always check if you'll trigger a 3-year, 10-year, or permanent ban. Consider applying for a waiver or green card adjustment now, before enforcement gets even tighter. If eligible, explore advanced parole and document everything. You may need to show proof of status or history at any time. Final warning: what used to be treated like jaywalking is now being prosecuted like a crime. June 2025 marks the beginning of the visa overstay crackdown era. You must be prepared, informed, and legally represented, because even one small mistake could cost you your future.